In this part of the session now, we're going to go slightly more in depth, looking at some of the key legal aspects as opposed to just the business issues. The topics which we're going to be covering are data protection, audit and inspection rights, service levels and service credit arrangements, liability, BC and DR as it's impacted by force majeure, and term and termination. Now again, some people might think, well, that's all legal, isn't that for the legal team to deal with? Hopefully from this morning's earlier session, you'll understand that you as an IT team will have a key input into all of these areas. So kicking off initially with data protection. And we've heard from the speakers today the importance of understanding where your data is. With regard to the Data Protection Act, as far as where there is any personal data involved, data relating to living individuals, an organisation is required to comply with all aspects of the Data Protection Act. The legislation imposes all those obligations on the customer organisation. So you, as the customer organisation, are required to have full compliance with the Act. Your service provider under the legislation is the data processor. The legislation doesn't impose any obligations upon them. That's for you to sort out, which is why it is important. So sometimes people put in contracts, customer contracts, the supplier will comply with the Data Protection Act. Fine, they don't have to do anything under the Act. The obligations for and all the liability for their breaches will fall upon yourselves as the customer organisation. And with regard to the data protection legislation, there's 8 key principles, and there's 2 principles in the cloud sphere which achieve some additional significance. First principle is this one on the screen, which deals with Principle 7 regarding some common sense things. So we've got appropriate technical and organisational measures against unauthorised or unlawful processing of personal data. So that people aren't just accessing that data when they're not allowed to, they're not doing anything illegal with that data, and protecting against accidental loss or destruction of damage to personal data. So it's preserving the integrity of that data. So these are things, as an organisation, from an IT perspective, you would envisage yourselves doing, you would envisage your service provider doing. But you need to go a bit further. You need to ask questions. It's going back to the due diligence points that we made this morning. That you need to be thinking about what are you as a service provider doing in terms of your physical and technical security. You need to also be thinking at another level. What are you doing as an operation from a management perspective? How are your staff being trained to make sure they comply with this? There's no point having security and then people blatantly breaching your security policies. You know, is there internal training to ensure that staff are aware of what their obligations are, what the restrictions are, to help you achieve compliance with this? The other important principle is that of Principle 8, and this is the one to deal with multi-jurisdictional issues. So under Principle 8, data cannot be transferred to a country outside the European Economic Area, the EEA, unless that country or territory has an adequate level of protection in place with regard to that personal data. To demonstrate such adequacy can be done in one of 3 ways, either through legislation, so if they're within the EEA, it will be covered by the data protection legislation. If it's certain US companies, then safe harbour may provide some comfort there. And if there's failings with those, then there's contractual measures and due diligence, which are important aspects. From a US perspective, if you have if you are using a service provider with a data center there, then the legislation is saying there's no adequacy there. You are in breach of the Data Protection Act by actually doing that, unless there are some additional safeguards added in. If a company is safe harbour registered, then there is a presumption of adequacy. The safe harbour arrangement requires companies to follow 7 principles of information handling to mirror some of the safeguards that the data protection legislation imposes. And it requires those companies to be responsible for keeping to those principles by the FTC, the Federal Trade Commission. And if you want to check whether your service provider is Safe Harbor registered or not, there is a link available which allows you to type in the name of the company and see whether their details are there. However, if the organisation that you are using, the service provider, isn't within the US and Safe Harbor, they're in India, for example, or they're in the US and they're not Safe Harbor registered, then you can still have a cloud service provider where you can work with them as long as there are additional safeguards imposed. And that will usually be undertaken through contractual measures. The legislation states that if there is a contract in place between yourselves and your service provider, which there will inevitably be, then that will give rise to a presumption of adequacy. And most organisations will use the model contract terms which have been approved by the European Commission. But it is also important still to undertake all the due diligence that we were talking about this morning to ensure that those safeguards are actually there. Which brings us to the topic of audit. And audit is an important subject at various stages in terms of dealing with your service provider. It can be initially, as we discussed this morning, to understand what is the service provider typically doing? What is it doing with other customers? What is it doing internally itself? It can be audit on an ongoing basis, so you've got the relationship and you want to undertake an audit to make sure those safeguards are being applied, that those security measures are being applied. But you need to bear in mind that diagram I had before about public and private cloud, that if you're dealing with a public cloud organisation, they are going to be more resistant to audits than a private cloud offering. And this is why if you're operating in a particularly regulated field for your industry, it's important to seek the advice of your internal compliance officer when you are looking at doing any kind of cloud deployment to ensure that your regulatory requirements won't be violated by you going into the cloud in the manner that you are envisaging doing so. With regard to audit, and this is where, again, CIOs need to get involved because lawyers, if left to themselves, can have lots of fun arguments about these things. Topics which normally come up are, what's the scope of the audit? What's the frequency and the timing? Can third parties audit? Now, some lawyers say, well, we want to be able to audit absolutely everything. You know, anything to do with this contract, we want to audit. They say, well, why do you as a customer or organisation need to audit absolutely everything of the supplier? You know, what benefit is it? And are you really going to do that? Are you really going to come in and audit absolutely everything? So don't adopt a kitchen sink approach. Adopt a more focused approach. What is actually important to your organisation? It's the security. You're going to want to ensure that you can audit the security arrangements. So you need to have a think about the scope and how wide do you want that or how narrow do you want that. Think about the frequency. Again, service providers don't really like the idea of their customers coming on site. It's disruptive, confidentiality issues, and it isn't something that they like, having people on their site. So what they will look to do is limit the number of audits. They will have restrictions in terms of how often a customer organisation can come in and do an audit. Sometimes these restrictions are fine, sometimes they're not. And again, as an organisation, consider how many times are we actually likely to audit this service provider and what they're offering, is that sufficient? It is always possible to have qualifications in there to say, you know, if we suspect there's fraud or security breaches, then we reserve the right to just come in on notice and undertake an audit. But if it's just a routine, run-of-the-mill audit, then we're happy with whatever proposal you've come, or actually, no, we need that increased. But that requires a bit of thought from yourselves, because the IT audit is going to be one of the key aspects of this type of arrangement. And it's what would you as an IT department feel is an appropriate auditing frequency? And then also, have you got the capability of doing it yourselves? Or do you not have the capability of doing the audit? Would you be engaging a third party to do that? Would you be having a PwC or someone else coming in and doing an audit? And if so, then that needs to be flagged at the outset as part of the key principles that you require audits. And those audits need to be allow you to do a certain frequency. You reserve the right to have third parties come and do those audits for you, just to make sure it doesn't become an issue down the line or when you're getting into the detailed contractual negotiations. There's then the issue of service levels and service credits, which are particularly important with a cloud arrangement. As after all, you are relying upon this service. That's what you're getting. You're getting a service, and you need to make sure that it is being provided to your minimum requirements. You need to make sure those levels are appropriate and that they are measurable. Again, the question which was raised earlier on today, how can you actually measure those? Because you've got so many interactions. You've got your customer infrastructure, you've got your supplier infrastructure, you've got the third-party infrastructure. How are those service levels actually going to be measured so that they are actually meaningful? And that's something that the lawyers won't be able to work out. That's something the commercial team won't be able to work out. That's something that the technical team, the IT team, will actually know, yes, this is what's important within your organisation, this is what's important where it touches our organisation, and that's what we require. So again, that's why it's important for yourselves to get involved in this type of discussion up front. It is also important to understand what the qualifications are. Many service providers say, we've got these great service levels, and we are offering this amount of uptime. But you need to understand, what are their get out of jail free cards? Where are they saying, well, under these circumstances, we're totally off the hook. And they will have a concept of planned and unplanned outages. Fine, they have to undertake maintenance. You have to with IT infrastructure. But you don't want that maintenance happening in the middle of the day during your busiest peak time or season. So that's something you need to be having a think about. And you need to be thinking about how much notice should be provided for those kind of outages. And if those kind of outages are going to occur, what are you going to do? What is your contingency? Are they going to be done in the middle of the night and it won't affect your business? Or, is your business a 24/7 and it will have an impact? What are you going to do? Do you have internal arrangements? Do you have other suppliers? Just as within outsourcing, and that's what cloud service arrangements are, a type of outsourcing, some organisations have multiple suppliers. Will you switch from one to another? And with cloud, that might be an option. So the other get out of jail free card is force majeure. So force majeure is supposed to be things which are beyond a party's reasonable control. However, it depends how sneaky the lawyer is on the supplier side, because it can mean a lot of other things and a lot of other get-outs. So it's making sure that these are genuinely things which are beyond a party's reasonable control, where they are off the hook. And it needs to be things which don't impact the business continuity and disaster recovery, because there is an interplay between these two. Force majeure kicks in when an event beyond your reasonable control occurs. Business continuity and disaster recovery kicks in when an event beyond your reasonable control kicks in. One of them gets you off the hook, the other aspect is going to be your safety net. So you need to make sure that they don't negate each other, and that's addressed properly as well. Service credits, again, very common in cloud arrangements, and they're the teeth of the service levels. There's no point having great service levels and then saying, well, it's breach. What happens? Well, nothing. Well, no, you can't have that arrangement because then they're meaningless. So what are the teeth that you're going to give these breach of service levels? Sometimes service providers will offer a service credit. So it's, an upfront arrangement that if we breach this, you will get a percentage of your monthly fees or this amount back as a credit. Service providers like to say, well, that's your sole and exclusive remedy. And once we've paid you that, that's it. You can't sue us for anything else. And you've had your compensation. And again, customers get a bit twitchy about this because they say, well, hold on, if we're only getting back £1,000 and we've suffered £10,000 loss, then that doesn't seem right to us. And it comes back to what we discussed this morning, that there needs to be a balance. And you need to be thinking, are the service credits sufficient for low-risk types of transactions? And for the high-risk ones, we want a different regime. Do we want a different category of service levels with different remedies for the more mission-critical service levels, the more high-importance service levels? So there are ways to skin this. It isn't a one-size-fits-all. You can say with those ones, yeah, we're fine with the service credits being our sole and exclusive remedy, because that's low risk and it's just a bit of a pain. But with these ones, if you breach them, then if you go below a certain threshold, for example, we want compensation. We want the right to actually